The next series of crimes we're going to talk about are crimes involving people. They constitute things like fear and forced action upon somebody, physical restraint, actually striking somebody in some fashion or using something to strike somebody, kidnapping, things like that. So the types of crimes we're going to talk about, specific types of crimes, we're going to talk about rape, we're going to talk about assault and battery, we're going to talk about kidnapping, we are going to talk about stalking, we're going to talk about, did I say kidnapping? For whatever reason, I think I said it 3 times. Kidnapping. Guess what? We're going to talk about kidnapping. Stalking, strangulation, unlawful imprisonment, all of these things involve crimes against people themselves. And we are going to start with talking about rape and sodomy. Rape is the taking of sexual intimacy with an unwilling person by force or without consent. Historically, rape was regarded as an offense that could be committed only against a woman who was not married to the defendant. Under common law, early American law, up until the 70s. I don't think of early American law as the 60s and early 70s, but since I was born in the 70s, I get it, that's my time. Husbands could rape their wives back in the 60s and the 50s and the 40s. And it was seen as a crime of violence, not only against her, but it was also seen as a property crime against her husband or her father. Common law recognized the crime of sodomy, which is penetration of the male anus by a man. That's what the crime was. And it was criminalized even if that act was consensual. And both of these laws have gone through many changes, as you can imagine. Today, the law recognizes that rape can be committed against females and males, and it's viewed both as a crime of violence and as a violation or as violating an individual's basic right to decide with whom to have sex with. The modern laws eliminated marital rape, that marital rape exception. The new laws, modern laws, have created a rape shield. It's called a rape shield. It protects and eliminates the need for prosecutors to have to corroborate a victim's story. We'll talk a little bit more about corroboration. Sodomy laws and anal sex began to change. Those laws began to change after the Supreme Court ruled that consenting adults are protected under the right of privacy, and you cannot criminalize any sexual activity. But despite this Supreme Court case, there are 12 states that still have sodomy laws on the books involving consensual partners. But I highly doubt that it's being used. I doubt people are being charged with it because it would be struck down if somebody was convicted under that as unconstitutional. So without further ado, let's begin talking about the crime of rape. Rape elements. What does a prosecutor have to prove? They have to prove a few things. All of the elements. This is a results crime, right? Specific intent crime, results crime, consequence crime. How you look at it, because not only does the prosecutor have to prove the act, they have to prove the criminal intent, causation, and the harm, and there are some attendant circumstances that have to be proven as well. What might you think that is based on what the last slide discussion was? Without consent. They have to prove that the act was without consent, and that's the attendant circumstance. We'll break it down. So what is the criminal act? Intercourse. That is the act, penetration with force or the threat of force. And the laws vary on what constitutes penetration. Penetration, there's a few definitions of what constitutes penetration. Penetration of a woman's vagina by a man's penis, that's all states. That is, all states recognize that as rape, or penetration for the Rape Criminal Act. Others include penetration of a woman's vagina by other body parts, such as tongue or finger, but any other body part. The Model Penal Code says not only those two, but also has penetration that includes oral or anal intercourse as well as rape. So forced oral sex or forced anal sex constitutes rape. And who commits rape? Either a man or a woman. And that's the majority of the states. A man or a woman can commit rape or be a victim of rape. Okay? Obviously, if a man or a woman can commit it. Before we jump into this example, I want to give you the New York statute. Now, one of the assignments you're going to have is to kind of review a sexual assault crime in New York State. But I'm going to give you the top count of what constitutes rape in the first degree in New York State, because you'll see, just like homicide, there are numerous ways that a sexual, and they don't call it rape, it would be some type of sexual offense. But we have rape in the first degree and a rape in a second degree in New York State, and then there's various forms of sexual assault types of crimes. So I'm going to work with rape in the first degree for our examples throughout our discussion. A person is guilty of rape in the first degree when he or she engages in sexual intercourse with another person. See, so we don't identify male or female. By forcible compulsion, that's number one. Or number two, who is incapable of consent by reason of being physically helpless. Or 3, who is less than 11 years old. Or 4, who is less than 13 years old and the actor is 18 years old or more. So that's our top count of rape. And rape in the first degree is a Class B felony, which is one of the highest. A is the highest, B is the next. So it's actually a mandatory prison sentence if somebody was convicted of that. And sexual intercourse is defined. I'm going to read you the definition, and it's not much of a definition. Sexual intercourse means, in New York State, has its ordinary meaning and occurs upon penetration, however slight that penetration is. So it's a very broad definition, so it encompasses a whole lot of things. And as you can see, when I read you that statute, you don't necessarily need force for a rape to have been committed. The statute also is expanded to include situations where the defendant doesn't use force or threats, but the victim may be in a vulnerable position, like they're unconscious, or they're intoxicated, or they're too young. And of course, it doesn't distinguish between whether or not the defendant was the cause of the impairment, i.e. drugging the victim. So it's very, very broad. And you guys might be aware of the Brock Turner case out in Seattle. It's on the West Coast, right? People versus Brock Turner. This is the young college kid who had sex with an unconscious woman and then got a very lenient sentence that struck all sorts of controversy. I'm going to put a link in Moodle. You can check out the story of how that happened and how he got caught. So let's talk about this example. Shortly after her husband left for work early in the morning, Sarah was startled to find Andrew, whom she did not know, in her bedroom where Sarah had just placed her 1-year-old baby in the crib. Andrew, clearly agitated, walked over to the baby's crib and, pointing angrily at the baby, said, "You know what I want? Get in the bed and take your clothes off and no one will get hurt." Frightened and concerned for the safety of her baby, Sarah complied. When Andrew took his clothes off, Sarah, fearing that Andrew might be HIV positive, said to him, "Please use a condom. If you don't have one, I do." Andrew took the condom offered and then had intercourse with Sarah. And the question is, do we have Taking burglary aside, because clearly Andrew's not supposed to be there, we're going to take that out. The question is, can Andrew be convicted of rape? We're going to have to go through some questions. Did he use physical force here? No, there's no physical force. And we're going to use that New York law that I gave you. So no physical force. What about, is there any threat of force to Sarah? No. There's no physical threat of force to Sarah. I don't get that. But is there any threat of force? Yes. To who? Her baby, her 1-year-old baby. And he didn't say, I'm going to hurt your baby. Right? He's just pointing at the crib angrily. But it was implied. Did you get it's implied? He didn't actually say, I'll hurt the baby. It's kind of an implied threat. And she complies. Did she consent? Would you consider the circumstances consent? Because that's at trial, when Andrew is arrested for rape, he's going to argue, well, she consented. She went over to the bed, she took her clothes off, she offered me a condom. The people have to prove that there was no consent. Did Sarah say no? Absolutely not. Did she resist? Not really. So let's go through some of these concepts I'm bringing up. Okay? Does she have to say no? Does she have to resist? Saying no is an unequivocal resistance. Okay? If you say no once, it's enough. You don't need to repeat it over and over again. The victim doesn't have to repeat it over and over again. So, but she doesn't say no. Resistance. Do they actually have to use force or resist when met with it? Her goal here was not to have her baby harmed. So does she have any choice under the circumstances? No. The test for resistance is going to be victim only needs to resist to the same extent as a reasonable person under similar circumstances. So it's our objective test again. We've had this already. So what would a reasonable person under these circumstances do? Not resist. They don't want their baby hurt. Only needs to resist to the same extent as a reasonable person. And his request or her request to wear a condom, that's actually reasonable. That would be reasonable. Request under the circumstances, not knowing his sexual history. That is not a form of consent. That is protecting yourself. That's the victim protecting yourself from what's to come. So in this instance, this is a rape case based on the threat. There is no consent here. There would be no consent here, and the threat is to the baby. And of course, as my example said, they had intercourse. Let's talk about this consent a little bit more. The victim's lack of consent. Because this is clearly this operates as an affirmative defense. And the prosecutor has to prove beyond a reasonable doubt that the victim didn't consent. So how do they do that? And can somebody give involuntary consent versus saying, yes, I consent? Can it be done involuntary and still be considered a lack of consent? All right, let's go through some. Actually, I want to just make one point on consent, and then we're going to do some examples. The modern view is to eliminate this element. It's kind of controversial. The argument is that it focuses the jury's attention to the victim's behavior rather than the defendant's behavior, right? Did she consent? Like, is everyone thinking, did she consent? versus what happened to her. And I'm using the him and her example because it's the most common. It also allows a defendant to claim they believe they had consent in almost every situation, which makes it hard to convict rapists. I had consent. And requiring the initiator of sexual conduct to obtain this unambiguous agreement of his or her partner ensuring that they are having physical intimacy is providing more protection to victims. Okay? So if you require the sexual, or the defendant, you require the defendant to establish the consent, it's kind of gives more protection to the victims versus having the prosecutor prove it. So it's kind of a controversial point, and it always comes up. So how do they do it? How does the prosecutor prove it? Well, the victim, one is the victim must be capable of giving consent. Okay, when a victim's incapable of giving consent, you're asking, what is the capacity of the victim? Is it a young age? Is it intoxication? Even if it's voluntary intoxication, that's not, oh, well, she got drunk, so she deserved it. No, that's not how that works, voluntary or involuntary. Also, incapacity by mental or intellectual impairment. What about involuntary consent? Can someone give involuntary consent? Also, by the way, just to step back, another way that a prosecutor, they're going to show whether or not there was resistance. I said no. I was trying to push him off. I punched him in the face and he got a black eye. Like, under the circumstances, can show that there was a lack of consent. Couple more points. Involuntary consent. Just like deception. There's two types. One is rape and one is not considered rape. So let's take a couple examples. Flush it out. So Jane says to Tom, should be Tom. Jane says to Tom, I believe you should only have sex with the one you love. Tom replies, it was love at first sight for me, Jane. I think you are the girl I will marry. Jane, moved by Tom's earnestness, says, oh, Tom, I'm so glad you feel that way. Let's make love. They have intercourse, and as Tom leaves that night, he turns to Jane and says, I don't want to see you again. Right? Is this rape? He lied. That's what happened. He lied. Is it forced? It's called fraud in the inducement, is the fancy word. And it is not actionable. That's not the criminalized behavior here. Why? Because Jane was still able to make her own decision about, her intimacy. Seduction and manipulation, they don't play a role. So this is not rape. What about this kind of situation where a victim goes to a medical professional to undergo a procedure and learns that a sexual assault was committed against them? Dr. Brown, a gynecologist, is about to give his patient Heather a vaginal exam. Contrary to professional protocol, he suddenly tells his nurse to leave the exam room on the pretext of locating some test results. Pretending to put on a latex glove, Dr. Brown inserts his bare hand into Heather's vagina and touches it for his own sexual gratification rather than to conduct a proper exam. Now, this, on the other hand, is considered fraud in the factum, and this is type of involuntary consent, and this is actionable. So make sure you distinguish between the two. And does the prosecutor have to corroborate the victim's testimony? The first question is, what is corroboration? It's something else. It's additional evidence that supports what the victim's saying. That's the general concept. In that common law, the victim's testimony alone was not sufficient evidence to meet the burden of rape. The prosecutor needed corroboration. And this concept of corroboration does not apply to other types of crimes. So let's say, for example, the crime of assault, and I punch you in the face. Luckily, you received no marks. You didn't have to go to the hospital. But I get charged because you make a claim that I punched you in the face and it's assault, but I say, no, I didn't. You made that all up because I gave you a bad grade. That can go, it's a he said, is what they say, he said, she said case. And they're extremely difficult to prove. But that's a case that is chargeable offense, and it's up to the jury to make a decision. And how do they decide? Based on the credibility. They want who they will believe. Most of the time, those kinds of cases get a not guilty verdict because you can't get to the reasonable doubt. But sometimes they do. But with a rape case, the law requires more than the victim's statement. And it's been criticized. The claim is that rape victims should be treated like the other crime victims and not held to a higher standard, i.e. they have to corroborate their story. Something else has to be there. I saw him running from the victim's place, or I happened to walk in on the event. There needs to be something else. Maybe the victim fought and caused some serious medical issue to the defendant, and they had to get medical treatment. Maybe that ties it in. She fought, so clearly it was resisted, and maybe that's how he got scratched up, or the defendant got scratched up. So the argument for the other side is that if you lessen the burden, though, if you lessen that burden of corroboration, there's more of a likelihood of convicting an innocent person. And how is that? How can you ease of fabrication? The fear of false charges, possibility of false conviction because of an emotional jury reaction. But it's difficult proving a charge of rape on he said, she said. It all will stem from credibility. All states have done away with the requirement of forcible rape. So you don't have to actually show signs of resistance, which makes it even more easy for a conviction. And also, states have done away with the corroboration requirement. The model penal code still requires it. So, nonetheless, it's still there. So things you got to think about. This is a very touchy type of crime. There's a lot of cases that go to trial in this county. When I say this county, I'm in Clinton County. We're in Plattsburgh. Most of the cases that go to trial are sex offenses, from rape in the first degree, all the way down to the lower level sexual offenses that when you take a look at the New York Model Penal Code that you will see, because most of them turn on he said, she said. There's very little corroboration evidence. The argument is when there's consenting, I don't want to say consenting, when the parties involved, the victims and the defendants involved are of age, adults. It gets a little different when there's crimes involving incapacitated or young victims. And it's just that it's hard to prove, but I'll say that in this county the conviction rate is nearly 100%. So the question is, we get the right person? Was it fabric? Because on the flip side of that, there have been statements that were made that were done in retaliation that upon further investigation ended up being false. And there's been cases in this county where the prosecutor gets almost to trial and they're preparing and they're re-examining their witnesses, and then they catch them up, and they're like, whoa. And then they have to stand before a court and dismiss the charges because it's learned that this didn't happen. So this is a very fascinating area of the law. And if there is during the semester a trial, right now trials are not happening because of COVID-19. If there is, I will let you know because it's a public courtroom, and you can certainly go and watch one of these trials. And if we were in the classroom, I'd have one of my prosecutor friends who works in this area alone, because they're usually a specially trained prosecutor, to come and speak. All right, I'm digressing. Criminal intent. We got to have a mens rea. At common law, there wasn't, the law didn't specify which criminal intent it was, which made it difficult for prosecutors to prove their case. And ultimately, the courts have determined that the mens rea was general and that the defendant knows. So what's the intent element for rape? General intent, knowingly. Knowingly committing the act, knowingly engaging in force, if force is required, knowingly engaging in threat of force, and without consent, knowing there's no consent. So this is what was established for common law, and it is established in the modern law as well. A person is guilty in New York State. I'm back to my New York State law. A person is guilty of, you'll see that there is no intent here, or there's no criminal intent noted in the statute. A person is guilty of rape in the first degree when he or she engages in sexual intercourse with another by forcible compulsion, or who is incapable of consent by reason of physical helplessness, or who is less than 11 years old and who is less than 13 years old, and the actor is 18 years old. And this is rape in the first degree. And I'm going to note here, because I don't think I tied it in with the criminal act, is it doesn't say threat of force, or it also doesn't have any force component except for by forcible compulsion. There's nothing less than that. So you need force, you need an incapable person, and then the age, less than 11 or less than 13 when the actor is 18, to be a top count for rape. If we're dealing with rape that doesn't have a force component, it's still rape, but it's a lower level crime. That might be one of the crimes that you guys picked out. I'm going to have you guys look at the statutes and pick one out and dissect it. But it doesn't have the criminal intent element in it. And our courts have determined that it's intentional. It has to be intentional under New York law. Not knowingly, intentional. All right, let's do one more. The causation and harm. Of course, the defendant's actions have to be the factual and legal cause. Remember, our but for the defendant doing blah, 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 this harm wouldn't have happened. And the legal cause is reasonably foreseeable. And that harm is the act of penetration. And penetration can be minor, slight. It doesn't have to be a full-on act. It has to be as slight as it is. A brief touching. So Jane, let's go through a series of examples. So Jane and Tom meet for drinks for the first time at a bar, and they have some drinks. Tom offers to give Jane a ride home. On their way there, Jane accepts Tom's invite to come up to his apartment. After kissing for a while on the couch, Tom starts unbuttoning her blouse. Okay, number one, that's our fact pattern. And first question. Jane tells Tom that she does not want to have sex with him. Tom pulls out a knife and says, if you don't have sex with me, I could get angry. Jane is terrified, says nothing, and lets Tom have intercourse with her. Is that rape? Yes. It's pretty straightforward. She says no. He pulls out a knife. We got force, and he has sex with her. Fact pattern. They're meeting for the first time. Tom invites her to come up. They start kissing. He starts unbuttoning her blouse. And then Jane tries to push Tom away. There's no weapons here. And says, I don't want to have sex with you. Tom, calling her a tease, pins her arms and manages to have intercourse with Jane. Is that right? Yes, it is. We still have force. We don't need a weapon. We have force. We have her resisting. And we have intercourse. Same facts as before. They meet for drinks for the first time. She accepts the invite to come back to the apartment. They're kissing on the couch. He starts unbuttoning her shirt. Jane is confused by this sudden turn of events and says nothing. Tom lies on top of her while she does and says nothing and has intercourse with Jane. Is this rape? Our law says that a defendant uses force that overcomes physical resistance or threatens the victim with serious physical harm, which is what we had in number 1 and number 2. In number 3, he only used force normally involved with having intercourse, and there was no threats, and Jane offered no physical or verbal resistance. So this is probably going to be a no. This will be a no. Let's talk about rape shields laws. What are they? In the past, I should say, until recently, and I have in air quotes, the 1970s, it was common defense strategy to attack the character of a rape victim. They used their past sexual history, their reputation, implying that women who had sex outside of marriage were immoral and therefore they're not believable. That was the attack. The rape shield laws that were passed in the 70s, they kind of curtailed this type of attack. I will say some of these laws are still a little old in light of, more modern views we have, and hopefully they'll go through some changes, but they certainly still work, but they do need a little work. Only allowing the victims, so these rape shields, what happened is they only allow the victim's past sexual history with the defendant to be allowed as evidence, not other partners. And the only thing that is allowed is the issue relative to consent, whether she consented to have sex with the defendant in the past. So it's very limited to what can come in. And it's the court that makes the ruling on these questions. And the laws can include other exclusions, like whether she asked the defendant to wear a condom, things like that. And basically these laws are, prevent people who file rape charges from having their privacy invaded and from being humiliated in court based on matters that aren't really relative to their credibility at all. Because the whole point is, if it's a he said, she said case, you're going to attack the credibility because the jury's going to decide whether or not who to believe. So if you can show, in the past, this, the sexual history and reputation of the victim, they might not be believable. Remember, the defendant doesn't have to take the stand. So there's chances you don't get to hear what the defendant is going to say, because the prosecution doesn't have to prove it. So these laws, these rape shield laws, certainly helped in victims coming forward to report the crimes and increase convictions. So those are the rape shield laws, and New York's rape shield laws are quite extensive. I'm not going to go into it, and it's not in the area where the charges are. It's in a different part of it's in our criminal procedure, because it's evidence. It's how the evidence comes in, and that's a question for the judge. Acquaintance rape. This is where they put the non-consensual rape. That you don't. This is where you don't need force in the crime, and the victim knows who the defendant is, the attacker. It's not from my example earlier. It's not the Andrew who shows up in the bedroom. Non-consensual rape. Rape without the use or threat of force. It's recognized. It's lets you review that point in the book. It's very short. Is that its punishment is lesser, and sadly, the punishment for it is less severe than forcible rape. I made that comment a couple slides before regarding the New York's top count for first, how it doesn't have the non-consensual, where there's no force involved. In some states, the crime is not even called rape, but it's called sexual assault. There's also sexual abuse or sexual misconduct. These are all terms that are used to describe various illegal sex crimes. And, how they use them is going to determine the level or degree. New York uses rape, uses sexual assault, uses sexual abuse, and uses sexual misconduct as they move down the ranking of grades. Spousal rape. At common law, it was perfectly legal to rape your wife. A man could rape his spouse. It couldn't work the other way. It's a man could rape his spouse. This is old 17th century theory because it was based on the mutual matrimonial consent and the contract the wife gives up herself to her husband. And this exception was still very much existent and on the books up through the 1970s until the rape laws changed and went through reform. There is specific statutes, though, downgrading it for spousal rape as a separate crime than for rape involving strangers. Statutory rape criminalizes sexual intercourse with a victim who is under the age of consent. That age is laid out in statute depending on the state. In New York, it's 17. The criminal act is the intercourse, the attendant circumstances. That's our age. The mens rea, I have a big question, mens rea. Criminalizes sexual intercourse with a victim who is under the age of consent. It is a strict liability crime. There is no level of intent. There's no need for the prosecutor to prove any intent, any mens rea. So the defendant who comes in and says, I didn't know she was 14, or she lied about her age, she looked 21. Is this a good rule? That doesn't matter. If the victim is underage, and you have intercourse with them, even if they agree, it is statutory rape. There are a minority of states that require reckless or negligent, like you should have known the age of your victim, or that the defendant took reasonable steps to learn the victim's age. This is the lying component, but they lied about it. No, I'm really this. Well, show me your ID. I don't have my ID with me. I don't know if those kinds of conversations actually take place. But nonetheless, it is a strict liability crime. No intent is required to be proven. And the harm is penetration. And there are, however, several variations of sexual acts involving minors. And what it would constitute for the level of rape. So, fondling a adult male, fondling a 14-year-old girl's breasts is considered some level of a sex offense. May not be statutory rape, but it is still statutory in nature. It's a strict liability crime. You don't have to show intent. So Again, I'm noting that as I have you review and pick a statute under New York law to dissect, and because there's so many that we could talk about. So I'm giving you the general concepts here that I want you to understand in a general form. But believe me, the laws are broken down, depending on what the act is. The statutory rape would be the intercourse, crimes of intercourse with victims under age. Other lesser offenses involving touching other areas, private parts of the body. All right, I'm digressing. Let's go into, and I'm also going to note before I leave this slide, you don't need force, right? It doesn't say force, it doesn't say threat of force. So like I said, they can consent and it can still be statutory rape. And it applies to men and women equally. Mary Kay, a high school history teacher, kept Jamie, a strapping 6-foot mature male 14-year-old student of hers, after school, often during the spring semester, having him serve as her paid student assistant. She groomed him with praise and responsibility. One day, after all of the students had left, Mary Kay started to kiss Jamie and then to fondle him. Jamie responded and they had intercourse. They continued the relationship for several months. Mary Kay became pregnant and these events became known. Jamie and Mary Kay insisted that they loved one another and wanted to get married. Is there a crime here? Yes, there is a crime here. Despite the consensual activities of Jamie, there is intercourse, which they can prove with Mary Kay being pregnant, I guess. And then maybe a DNA test to determine if the child was Jamie's. But it sounds like all of the information has been disclosed, so nobody's denying anything. And Mary is an adult. I don't tell you how old she is, but she is a high school teacher, so she's certainly of adult years having sex with a minor. That's statutory rape. And yes, Mary Kay can be prosecuted. Let's talk about the sodomy laws and the oral copulation laws. So there are states that recognize the difference between rape and sodomy. Other states, like I said, including New York, define them under terms of sexual assault, sexual misconduct, sexual abuse, criminal sex acts. There's aggravated sexual abuse. There's a number of different categories. And they won't have the law of sodomy, right? The law of oral copulation, not in New York anyway. They don't have them spelled out. So those states that recognize sodomy separately define it as follows. Forcible penis to anus penetration. And then all of the other rape elements have to be there as well. The lack of consent, the intent, the lack of consent, the causation, and the harm, they all have to be there as well. But that is the act, that is the criminal act, the forcible penis to anus penetration. Oral copulation is the forcible mouth to sex organs or anus penetration. And again, all the other rape elements need to be there. The criminal intent or the mens rea, the lack of consent, and the causation and the harm. And the Supreme Court has ruled, as I said earlier, that consenting adults engaging in this conduct is not criminal and unconstitutional, and it's unconstitutional if criminalized. But despite this, statutes still exist with regards to it. But as I said, it will probably be deemed unenforceable if it's even prosecuted or charged. Incest. This is different from what we've been discussing. This is having sexual intercourse with someone you cannot legally marry because of a family relationship, even if it's consensual. Okay, it's nothing to do with force or consent. You can't have sex with your siblings, right? That's what incest is. If you are first cousins and you're both 21 years of age and you agree to have sex, it constitutes a crime of incest. That's pretty straightforward, and that exists in the state of New York. Let's see. Where am I going next with this? Oh, before I switch, with regards to incest, this is not the same as forcibly having sexual intercourse with a relative. That is still rape. That would be the victims under the age. It also could be statutory rape. Incest is strictly having sexual intercourse with someone you can't be legally married to. And it's the result of some sort of family relationship. Okay? Sexual predator laws. These were enacted where defendants, because of defendants' conduct, they elevated our sexual assault charges, where a defendant intentionally seeks out underage victims with the purpose of sexually assaulting them. So it's not a matter of just having the sexual intercourse with an underage victim. This brings it one level up. This is the defendant sought out underage victims with the purpose, intent of sexually assaulting them. Remember that TV show, To Catch a Predator? That's where these laws fall in. And in New York State, there are laws. Well, one of our top count is Class A, the Class A felony. And it turns on how old that victim is. If they're under the age of 12, then you are going to prison. As long as someone who committed murder here, it's Class A felony. Grades. Like I've been saying the whole stretch of this class, obviously the crime of sexual assault will be classified by a grade, and it's going to be dependent on the factors of the crime. Some of the factors: force, was there a weapon, the age, the victim, the age of the victim, the age of the defendant, the disability of the victim, was it a gang, was it more than one person engaging in the sexual act? We have like gang rape, that's another form of rape. Was there another crime committed? Was there a burglary and then the rape, like the first example involving Andrew and Sarah? And the grade determines the severity of the penalty, of course. And in New York, forcible rape, the top count is a B felony, but I also just told you if it's a sex predator offense, it's a Class A felony. There are numerous types of sexual assault offenses, all the way down from the misdemeanor level and all the way up the chain. Depending on the jurisdiction, a crime can be elevated based on the weapon being used. Like I said, if it's a gang rape, the age of the victim, as you recall from the earlier discussion in this semester, the grade for the offenses is determined on the harshness of the punishment. Let's see. I think that is... a couple more things. Sex Offender Registration Act, or SORA. This is kind of it relates to sex offenses. It's kind of a side issue, and to put it into context, think about DWI, driving while intoxicated. All right, if somebody is arrested for DWI, they go to court. It's a first-time offense. It's a misdemeanor. You get some sort of penalty or you get some sort of punishment, and then you learn that you lose your driver's license for a period of time. That's not a law. That's not a criminal law. It's not anywhere in the criminal statute. That is the Department of Motor Vehicles who decides that, if somebody has a driving while intoxicated criminal conviction, we are going to suspend or revoke, whatever it happens to be on the charge, this person's license. And so I call it like an extension, a collateral consequence of the conviction. And that's what the Sex Offender Registration Act is. This isn't criminal penalty. It does fall within the penalty component, and the defendant has to be aware that it exists. It's not something that shows up. You have to be told, by the way, if you're convicted of a sex offense, you have to register as a sex offender. But it's a civil component, or a collateral consequence, as I like to say. So we have two versions. We have Megan's Law and Jessica's Law. And Megan's Law is mandatory. for, I believe, every single sex offense, whether it's a misdemeanor up in New York State. There might be one or two that it's not, but I am pretty darn sure it's all of them. And they're levels. They have a level 1, a level 2, and a level 3. Level 3 is the worst registration requirement you need, and level 1 is the lowest level. And you don't need to know all of these distinctions. The level 3 is you got to register for the rest of your life. That's how bad your crime is, and that's probably the sex predator case. Usually those ones involving children are going to be in the level 3. Level 1, you have to register for about, I think it's 10 years, and 2 is 20 years. But basically what it is, when I keep saying register, is, and I'll note that it's named after, it says it's Megan's Law and Jessica's Law. They're actually named after children who were sexually assaulted, and then Megan was murdered. I don't recall if Jessica was too. But then that's how these laws started to come around. We need to make sure we have more restrictions on our predators. And so Megan's Law requires individuals convicted of a sex crime to register with the county sheriff where they reside to be monitored and controlled. And depending on your level, the notification is public. Right now, because we have the internet and all sorts of access, you can look up sex offenders. You might not get all of their information depending on which level they're registering at. A level 3, you're going to get a whole lot more information than if they're a level 1. But the key to information is, what you'll find on them all is you can go in and you can type in your address and you can see where the sex offenders live. And they do this because you want to know if you've had children, or but they can't live, if they're on some sort of supervision like parole, they can't be near a school area. But I'm digressing with a lot of information on Megan's Law, but that is the most common one, and that's mandatory, and it's required. Jessica's Law, for high-risk individuals, there could be a requirement that they have GPS monitoring, and they could be subject to extended commitment, meaning that they've spent all their time on their prison sentence and they're about to be released, but they don't want them released into the community because they just will definitely recommit. There's something that's terribly off with them. I can't give you the exact formula of what they use, but the state, before they're about to be released, and this is usually very rare and only involves those sexual predator types, is that they will request the court, and there would be a big civil hearing, and ultimately ask for a civil confinement where these people will be held and not released into our community. But that's a very big step, and that's what Jessica Law is. And I just want you to know that it is out there. I think it's mentioned in the book. And that concludes our discussion on rape. We're going to turn to assault and battery next.